Did you guys see the Scott Peterson thing?
No.
Okay, so yeah, there's an issue with Scott Peterson. He was convicted 20 years ago. We've got the Ghislaine Maxwell issue. One of the jurors apparently lied in a fairly severe way on their juror form, and so the courts are now struggling with that same issue in the Scott Peterson case.
Scott Peterson, like that was like over a decade ago, wasn't it?
It was 20 years ago. Yeah.
Like like I was a baby practically.
Yes.
Almost. Not quite, but like metaphorically.
Yes.
Interesting.
20 years ago, and this information apparently has somehow just come to light, and so it's basically the same issue for Ghislaine Maxwell. So it's another.
What was the lie? What was the lie?
Oh, I couldn't remember exactly off the top of my head, but it was fairly severe, as I remember from my reading. But I don't remember exactly what it was. It was enough to get my attention.
Well, just so everybody understands too, usually interest of justice, there's no time limit on it. So, you know, the court's justice does prevail in situations like this where you can show a conviction was unjust. You can pretty much bring it any time. So,
but they almost never work. Like, for example, in the Second Circuit, the rogue jury, the rogue lying juror on the voir dire has worked. I believe as of 2018, it had worked 0 times.
Wow.
In the history of the Second Circuit.
Yes, that's right. You're correct. I forgot that fact, but yes,
I think it might have worked once recently, but I haven't. When I was reading up on it, there was something I was reading from 2018 which said it had never worked. So, I just want to clarify something I said earlier. The outrageous government misconduct was brought up in dicta in U.S. v. Russell in 1973. So I didn't remember the name of the case. I wanted to just clarify that out for you guys.
Okay.
But So, and that also is something that almost never works, and a lot of defendants try and rely on in order to overcome their predilection issues when they're claiming entrapment. But so it's interesting with Scott Peterson that they can actually come up with something from 20 years ago to say that, hey, that a juror actually remembers lying. Here's the thing which might help Peterson, which I think Maxwell is going to struggle with, which is that when they're measuring to see, okay, why would we say that this lie merits a new trial? Because they won't be found innocent at best when you're claiming that a juror lied and should not have been on the jury. Because just to clarify for anyone in the audience who's unclear what we're talking about when lying. So when they're doing the process of jury selection, in many trials, not all trials, many trials, they'll have the potential jurors fill out a questionnaire, and then the purpose of the questionnaire is to establish whether or not they have bias, which will affect their ability to reach a decision based on the facts and law of this particular case. So if you're lying on it and you cover up some facts that are affecting your ability to judge the case fairly, so that would, in theory, create a basis to overturn the conviction. Now, it would never work in the favor of the state. So if someone is a rogue juror and they're trying to get someone off and they successfully do that, well, I can't even imagine. I'm fairly certain that it would be something that the state would not even be allowed to raise. Only the defendant. Yeah,
because jeopardy attached.
Right.
So the state couldn't raise it.
Even though you would think jeopardy should not have attached, you would think that because of the fact that there's been bias, it's never been fairly decided. So
you were never in jeopardy. Yeah.
You were never really in jeopardy because this juror got in there. But let's just
that happened with the powder bar for Cocaine Cowboys, where the jurors were paid off. And that was when they said that they were never really in jeopardy because their jurors were paid off. So jeopardy.
Well, that definitely, yeah. If you bribe a juror or bribe the judge so the fix is in, that would defeat double jeopardy issues. So that you could retry that case. But just because a juror stuck through, I don't think it's going to work.
Okay, hold on. Okay, so let's think about this for a second. I'll give you in a hypothetical. Remember that guy who was shot, the white guy who was shot at a BLM rally? Like they snuck up on him and killed him, right?
Remember that? Like Oregon, was it?
Where was that at? Was that in
somewhere on the West Coast? Oh. It was somewhere. It was definitely on the West Coast.
I remember the
state. I remember hearing about this.
It was a guy who was basically killed by an Antifa guy. For being a white guy who was part of some prayer group or something like that, who was in the vicinity of BLM. I believe he was part of. There was actually 2 white guys that I recall being killed at various BLM rallies by Antifa. So here's my point: if someone is hardcore BLM, like really crazy woke, whatever, and there's a voir dire, and they lie about that intentionally for the purposes of getting on the jury. Now there's a trial that happens there. I don't know why that person, and let's say they're the head of some BLM chapter, and they themselves have been like really, talking about killing anyone who doesn't support BLM. That's the juror that gets on there by lying on his question. How is now he succeeds in getting this defendant off? He gets on the jury and succeeds in getting the juror off. How would we think that jeopardy is ever attached when this guy was sitting there was sitting there in the jury and had zero chance he was ever going to convict on anything for the person who killed an anti-BLM person? So to me, it's the same thing as if he was bribed, and there's never been any jeopardy attached. And yet, I agree with what you guys seem to be indicating, which is the fact that probably the state would never succeed in getting a new trial because they would successfully argue double jeopardy. In other words, go ahead.
No, well, there's I like to call it the inference leap. And the first with the bribe, I'm paying you for a not guilty verdict. So there's no inference there, right? But in your retort, the inference would be that this person who has all these political motivations and even lied couldn't be fair, right? So I agree that the person making the decision would have to buy into the inference that person there was no evidence that could make that person convict that person. If you can, that argument could be made, but that I think is where you're trying to overcome, because it's just like if that person was like the BLM guy from the Chauvin case, and if you can prove that guy intentionally lied, right? He said he never went to a BLM rally. Then you got the pictures of him at the BLM rally or whatever with the shirt on. But if you can't prove that he was in the tank, like if you prove he got paid, he's in the tank. But if you can't prove he's in the tank, but prove he may be biased, then I don't think that's enough to overcome the standard to say that he was never in jeopardy. Because the argument on the side is he was in jeopardy, and now you're making an inference that everybody who's on that political spectrum, on that political side, is suspect.
Interestingly, this is almost like outrageous juror misconduct. It's the exact opposite perspective, where it's like you have to show this level is so high that it's not just that the government was entrapping, but there was or that the juror was entrapping the verdict, but it was really being outrageous in order to get past that hurdle. Which is, I think, what the Second Circuit essentially has basically said. In order to succeed, so what's happening in the Maxwell case, for those of you who are curious about it, and I've actually been criticized by some that I haven't been following up about the legal developments that have happened. Part of the reason I haven't been following up is because it's all been secreted away by the court. I can't read any documents. No one has access to anything. It's all under seal. In fact, that's one of the things that the prosecutors have said. Why is this under seal? Like, why is this whole discussion under seal? And defense has said, well, we want to keep it under seal because we don't want this juror who's in question to tailor his answers that are going to be coming up at a hearing based on the arguments that are being made here. So we don't want them to even see what our claims are. Otherwise, he's going to lie. But the state has been arguing to open it up and enable everyone to be able to see it. But the part of the reason that it's so difficult to succeed is because the only focus of the court, the only thing the court is permitted to focus on is the moment of answering the jury questions. Any steps that juror took later on, and this juror has admitted to taking steps that helped lead to Ghislaine Maxwell's conviction, that by basically testifying and saying, hey, I was a victim myself. This is what the juror said. I think his name is Scott or something.
He testified?
Well, no,
he didn't testify. In the jury room, he pretty much testified, or he supported the testimony of the victims by saying, yeah, these victims who don't remember, I'll tell you this much. I was a victim too. There's certain things that stick out in your mind very clearly, and other things become very, very blurry. And I remember the color of the carpet. I remember, this and that, but there are other things that are very, very blurry. So when they say they remember certain details and other parts are blurry, that's exactly the way it works with victims. So this is what the jury was doing when they were sequestered away, when they're trying to reach a verdict on Maxwell. All of that conversation, which he admitted to in interviews with reporters, that conversation is irrelevant for purposes of overturning this
No, well,
conviction. All that's
Joe,
relevant is
I
what
wanna-
happened at the moment and what his intent was when he lied at the voir dire.
Joe, I'll even go further than that. The rules, the federal rules of evidence, specifically dictate that jurors, anything they say about deliberations, is specifically excluded from any courtroom proceeding at all. So
Yep.
even if he says that the court can't, even if he was going to court and say this is what happened, they could not use any of that in any decision because the rules specifically say juror deliberation. What happens in the jury room is like a black box. Whatever happens, unless you can prove somebody got paid or something like that. But otherwise, then yeah. So that evidence will never actually even see the light of day, unfortunately.
Interesting. That's wild.